Hello again, my name's Gabe Zona. One of my viewers sent me a rather interesting article. I'm going to turn this into a video. I'll also attach the link. And this is posted on the Harvard Law Review forum. You know, the Harvard Law Review that the chosen one supposedly head up. Anyway, the title is On the Meaning of, quote, Natural Born Citizen, end of quote. Commentary by Neil Cattell and Paul Clement, dated March the 11th, 2015. We have both had the privilege of heading the office of the Solicitor General during different administrations. We may have different ideas about the ideal candidate in the next presidential election, but we agree on one important principle. Voters should be able to choose from all constitutionally eligible candidates, free from spurious arguments that a U.S. citizen at birth is somehow not constitutionally eligible to serve as president simply because he was delivered at a hospital abroad. The Constitution directly addresses the minimum qualifications necessary to serve as president. In addition to requiring 35 years of age and 14 years of residency, the Constitution limits the presidency to, quote, a natural-born citizen, end of quote. All the sources routinely used to interpret the Constitution confirm that the phrase, quote, natural-born citizen, end of quote, has a specific meaning, namely, someone who was a U.S. citizen at birth with no need to go through a naturalization proceeding at some later time. And Congress has made it equally clear from the time of the framing of the Constitution to the current day that subject to certain residency requirements on the parents, remember that, someone born to a U.S. citizen parent, now it's parent, it was just previously parents, generally becomes a U.S. citizen without regard to whether the birth takes place in Canada, the Canal Zone, or the continental United States. While some constitutional issues are truly difficult with framing era sources, either non-existent or contradictory, here the relevant material clearly indicates that, quote, a natural-born citizen, end of quote, means a citizen from birth with no need to go through the naturalization proceedings. The Supreme Court has long recognized that two particular useful sources in understanding constitutional terms are British common law and enhancements of the First Congress. Both confirm that the original meaning of the phrase, quote, natural-born citizens, end of quote, includes persons born abroad who are citizens from birth based on the citizenship of a parent. Now we're singular again. As to the British practice, law in force in the 1700s recognized that children born outside of the British Empire is subject of the Crown, were subjects themselves, and explicitly used, quote, natural born, end of quote, to encompass such children. Let me repeat that. As the British practice law in force in the 1700s recognizes that children born outside of the British Empire to subjects of the Crown were subjects themselves, and explicitly used, quote, natural born to encompass such children. Doesn't that mean that Barack Hussein Obama is in fact a British subject? These statutes provided that children born abroad to subject of the British Empire were natural-born subjects to all intents, constructions, and purposes whatsoever. The framers, of course, would have been intimately familiar with these statutes and the way they were used, terms like, quote, natural-born, since the statutes were binding law in the colonies before the Revolutionary War. They were also well documented in Blackstone's commentaries, a text widely circulated and read by framers and routinely invoked in interpreting the Constitution. No doubt, informed by this long-standing tradition, just 3 years after the drafting of the Constitution, the first Congress established that children born abroad to citizens, plural, were U.S. citizens of birth and explicitly recognized as such children were natural-born citizens. The Naturalization Act of 1790 provided that, quote, the children of citizens, plural, of the United States that may be born beyond sea or out of the limits of the United States shall be considered as natural-born citizens. So which one is it? Is it citizens, is it parent, or is it parents? Provided that the right of citizenship shall not descend to persons whose fathers have never been resident in the United States. Provided that the right of citizenship shall not be descendant to persons whose fathers have never been residents in the United States. The actions and understanding of the First Congress are particularly persuasive because so many of the framers of the Constitution were also members of the First Congress. That is particularly true in this instance, as 8 of the 11 members of the committee that proposed the natural-born eligibility requirements to the convention served in the First Congress, and none objected to the definition of, quote, natural-born citizen, end of quote, that included persons born abroad to citizen parents, plural. You see how this is sort of very confusing and misleading? The proviso in the Naturalization Act of 1790 underscores that while the concept of, quote, natural-born citizen, end of quote, has remained constant and particularly includes someone who is a citizen from birth by descent without the need to undergo naturalization proceedings, the details of which individuals born abroad to a citizen parent qualify as citizens from birth have changed. The pre-revolution British statutes sometimes focused on parenthood, such as those children of citizen fathers were granted citizenships at birth. The Naturalization Act of 1790 expanded the class of citizens at birth to include children born abroad of citizen mothers, as long as the father had at least been a resident in the United States at some point. But Congress eliminated that differential treatment of citizen mothers and fathers before any of the potential candidates in the current presidential election were born, which means that Barack Hussein Obama is not considered to be a naturalized born American citizen. Listen to it. But Congress eliminated that differential treatment of citizens' mothers and fathers before any of the potential candidates in the current president election were born. Thus, in a relevant time period and subject to certain residency requirements, children born abroad of citizen parent, now again singular, were citizens from the moment of birth and thus are natural-born citizens. The original meaning of natural-born citizen also comports with what we know of the framers' purpose in including this language in the Constitution. Excuse me. The phrase which appeared in the draft Constitution shortly after George Washington received a letter from John Jay, the future first Chief of Justice of the United States, suggesting whether it would not be wise and seasonably to provide a strong check to administration of foreigners into administration of our natural government, and to declare expressly that the commander-in-chief of the American army shall not be given to nor devolve on any but a natural-born citizen. Can you see how if this was applied, we wouldn't having the issues that we're having? We wouldn't be having them at all. As recounted by Justice Joseph Story in his famous commentary on the Constitution, the purpose of the natural-born clause was thus to cut off all chances of ambitious foreigners who might otherwise be intriguing for the office and interpose a barrier against those corrupt interferences of foreign governments in executive elections. God. The framers did not fear such manifestations from those who were U.S. citizens from birth just because of this happenstance of a foreign birthplace. Indeed, John Jay's own children were born abroad while he served on diplomatic assignments, and it would be absurd to conclude that Jay proposed to exclude his own children as foreigners' dubious loyalty from presidential eligibility. While the field of candidates for the next presidential election is still taking shape, at least one potential candidate, Senator Ted Cruz, was born in a Canadian hospital to a U.S. citizen mother. Despite the happenstance of a birthplace across the border, there is no question that Senator Cruz has been a citizen from birth and is thus a natural-born citizen within the meaning of the Constitution. Indeed, because his father had also been a resident of the United States, Senator Cruz would have been a natural-born citizen, even under the Naturalization Act of 1790. Similarly, in 2008, one of the two major candidates for president, Senator John McCain, was born outside the United States on a U.S. military base in the Panama Canal Zone to a U.S. citizen parent. Now again, we're talking parent. Despite a few spurious suggestions to the contrary, there is no serious question that Senator McCain was fully eligible to serve as president, other than the fact that he was a traitor. Wholly apart from any murky debate about the precise sovereignty status of the Panama Canal Zone at the time of Senator McCain's birth. Indeed, this aspect of Senator McCain's candidacy was a source of bipartisan accord. The U.S. Senate unanimously agreed that Senator McCain was eligible for the presidency, resolving that any interpretation of the natural-born citizenship clause as limited to those born within the United States was inconsistent with the purpose and intent of the natural-born citizen clause of the Constitution of the United States, as evidenced by the first Congress own statute defining the term natural-born citizen. And for the same reason, both Senator Barry Goldwater and Governor George Romney were eligible to serve as president, although neither was born within a state. Senator Goldwater was born in Arizona before its statehood and was the Republican Party's presidential nominee in 1964. And Governor Romney was born in Mexico to U.S. citizen parents and unsuccessfully persuaded the Republican nomination for the president in 1968. There are plenty of serious issues to debate in the upcoming presidential election. The less time spent dealing with spacious objections to candidates' eligibility, the better. Fortunately, the Constitution is refreshingly clear on these eligibility issues. Clear as mud. Absolutely clear as mud. This whole thing just contradicts itself. Parent, parents, citizen, citizens. Wake up, folks. To serve, an individual must be at least 35 years old, a natural-born citizen. 34 and a half is not enough, and for better or worse, a naturalized citizen cannot serve. But as Congress has recognized since the founding, a person born abroad to U.S. citizens, parents is generally U.S. citizens from birth with no need for naturalization. And the phrase natural-born citizen in the Constitution encompasses all such citizens from birth. Thus, an individual born to U.S. citizen parent, whether in California, Canada, or the Canal Zone, is a U.S. citizen from birth and is fully eligible to serve as president if the people so choose. Well, what about Marco Rubio, whose parents, neither one was a citizen? They were both Cuban citizens. What about Bobby Jindal, whose parents came here on a green card, and they were green card holders when Bobby Jindal was born? And what about Rick Santorum, whose mother was not an American citizen? Folks, you see how we're getting screwed? This whole document contradicts itself, left, right, and center. It talks about parent, talks about parents, it talks about citizen, it talks about citizens, it talks about the British Act as far as naturalization is concerned. A subject born to a British subject are themselves British subjects. So what the hell does that mean Obama is? Come on, folks. This is all double talk, googly wash to try to get Ted Cruz as a presidential candidate. Sorry for the coughing, but there was a lot to read here. I don't know, folks. We're getting bamboozled. It can't be both. It can't be citizen and citizens. It can't be parent and parents. It can't be mother. It can't be father. What is it? And the Supreme Court's ruled, I believe, on two separate occasions. Not this defunct Supreme Court. Previous Supreme Courts. They've ruled on a definition of natural-born citizen. And this, what I just read, isn't what they ruled and agreed upon. What else can I tell you? Not a whole lot. Again, sorry for coughing. I'm not going to redo this. Too much to go through. You don't want to hear it, don't listen to it.